Relationship breakdowns seem to be more common in our society. Statistics support many of our own observations that a lot of marriages and legally recognised relationships will end, and very commonly there are unfortunate consequences following that. Those consequences may be financial, material in other ways, and most seriously personal, as children frequently are caught up in a deteriorating situation of complication, aggravation and legal processes. I know of many instances where an initial determination for a civilised separation process have become quite the opposite after the legal advice and intervention. Legal advice and intervention, I should say. There's a movement in family law designed to prevent this occurring, or try and stop it occurring. It's called collaborative law. Joining us today to talk about collaborative law is Juliette Ford, a director of Consensus Family Lawyers here in Canberra. Juliette, how are you?
I'm very good, thank you, Greg. Thank you very much for the invitation today.
Well, it's a subject that, unfortunately, you guys are in great demand out there in the community.
Yes, that's very true. Sadly, the statistics say that 1 out of 3 first marriages end in separation, and in relation to second marriages, surprisingly, the statistics are about 2 out of 3 relationships. So, yes,
many people going third time around are happy to contribute to the statistical work on this, or not, Juliette?
Oh, look, I haven't ever managed to get to the point of the third time round, but those that are ever optimistic head down the path again, and you know, society is changing, expectations about relationships are changing. So, to some extent, it's becoming more common for people to be serially I can't say the word. Monogamous, rather than being in the same relationship for all of their lives. And that's just a reflection of societal attitudes changing.
When those relationships break down, and I don't say this disrespectfully, but the legal industry has been a great beneficiary of those. There are often protracted disputes about the actual divorce process, and then settlement of the financial assets of the union, and working out arrangements around the fruits of the union, the children and whatever else. Yes. Has been a fairly antagonistic and disrespectful process at times. Collaborative law sets out with a different set of objectives. What is collaborative law, Julian?
Collaborative law is really a response by lawyers who have looked at the traditional adversarial system and said that really doesn't work for anyone. It doesn't work for the people involved. It doesn't really work for the lawyers, although, yes, it is an industry which is very expensive, and it's expensive for people to engage lawyers. But lawyers have really looked at the system and thought there must be a better way to assist people from getting to the point where they've made a decision to separate to that final point where they've reached agreement in relation to the arrangements for their children and in relation to financial issues. What lawyers who have been involved in the traditional system find is that the whole basis upon which that traditional system operates prevents people from communicating effectively, exploring options to resolve things, to actually think outside what you might think of as like a boxing ring. I head up the blue corner, they head up the red corner, and we might do it nicely, but at the end of each round we'll come out, have a box and go back into our corners. We don't actually talk about what each party's concerns are. We don't talk about what their fears are. We don't talk about what the underlying motivations might be, why someone says, I must have this, this and this, or why the children must spend this amount of time with me and a different amount of time with the other person. So the whole structure, if you like, of traditional litigation really promotes what I would call a competitive negotiation rather than what is, in a collaborative world, an interest-based negotiation. A nice example of that, and it's an example I use a lot when I'm talking to people, is when you buy a used car. To define a competitive negotiation, you go down to buy that car and you want to pay the least amount possible. And the person who's selling the car to you wants to sell it for the most amount possible. Neither of you really care about why it is they need the most amount possible. They might have a lease to pay, expenses to pay. The whole running of the business is founded upon that cost for that car. And the person trying to buy it at the least amount is, of course, got their own family budget, a certain amount they wish to spend. So you're one person starting high and the other person starting low. Perfect example of a competitive negotiation. You know you'll end up somewhere in between, and depending upon how successful you've been, it'll either be closer to your mark or closer to the other person's mark. And I say to people, is that the way you want to negotiate about your children? Do you really want to put in an ambit claim of the children spending this many days with you and this many days with the other person, and the other person doing a similar thing? and then you're coming back with a negotiated resolution? Or do you really want to look underneath that and see what sort of arrangement's going to be best for the children, and how can we work to get all the information necessary to try and decide what sort of arrangement would be best?
I can see the approach you're talking about making sense if a relationship is finished and it's been a respectful and a mutual recognition of that. If the breakup of the relationship was brought to a head by some more harmful behaviour on the part of one party, can you still get people to talk like that, or do these things reach an area where the blue corner and the red corner are just never going to meet?
Yes, you can, is the short answer. What I have found is if I can see people early on after they've separated, where there's still a semblance of some goodwill, there's still some commitment to trying to do this broadly, amicably, but there are real challenges because we're all just human. You know, you'll say things and you think, oh, could I just grab that back? An argument will arise and you think, how do we find ourselves into this? Because the dynamic of the relationship that's come to its end has started to have this fairly negative dynamic to the way in which you communicate with each other. And if you can grab people before that becomes so learned and so entrenched, then you can bring them into a collaborative space, where one of the key issues you'll talk about right at the beginning is what are going to be our road rules, what are going to be the communication road rules, and how are we going to keep each other on track in relation to this. And so it's really small steps before you do big steps. Even when it is entrenched, if you like, the whole process of collaboration where everyone is signing a contract saying we're not going to go to court means that creates a container where if somebody does go a little bit off the rails, or you suddenly say something which you think, oh gee, I've just broken one of the road rules, you've got the other three people involved in the process say, hey, come back.
And when you say those four parties, of course, it's the two people and their respective legal advisors.
The difference between my boxing ring analogy and having the two teams of two is that in a collaborative law environment, you've got one team of four. So you've got one team trying to solve one problem. How are we going to divide up this asset group, which has really quite well supported one family living in one household? How is that going to stretch to support this family now living in two households?
If I can continue the sporting analogy, if I jumped into the ring and I said, well, we're having a boxing match, and you jumped in and you said, no, we're having a wrestling match, it's never going to work. So underlying all of this is that both parties need to be represented by lawyers who are prepared to play collaborative law rules, I'd suggest.
That's correct. You are doing your client a disservice if I jump into the boxing ring and say, let's talk interest-based, when the other person is saying, let's talk competitive negotiation. You're both not on the same playing field. And so everybody has to be on that same playing field, understanding what the rules of the game are, which means the two lawyers need to be trained in collaborative law. And all the other very important aspect of collaborative law is that everybody signs the contract, because it's that contract which